Greetings, this is Christine Van Pelt on Gibson County, Indiana, State Coordinator and Lead Recording Secretary for the Indiana Assembly. And we are continuing with Brent Allen Winters' Declaration of 76, United States Constitution, a common lawyer comments, clause by clause. The link is at the top, commonlawyer.com, to be able to purchase his book and study materials. He has other educational material to support you as well, and he is on Terre Haute, Indiana. He has not presented status to the Indiana Assembly, but he has done all of this legwork. So we'll continue with this reading, and let me get these things changed up here so we can get to, here we go. We'll continue. Amendment 4. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Comment. The Fourth Amendment says, Justice Story is little more than the affirmance of a great constitutional teaching of the common law. It requires that government, before searching or seizing things or people, must persuade a judge neutral and detached from the matter that it is more likely than not that certain described evidence of crime or one wanted for doing a crime, will be found at the place described. If persuaded, the judge will sign and issue. The judge will sign and issue proper warrant to search the place described for the persons or things to be seized. Anything less is unreasonable. Contrary to some federal courts, Amendment 4, by a fair reading, does require a warrant. The concerns of those that ratified the Fourth Amendment were general warrants and writs of assistance. Incidents on both sides of the Atlantic gave rise to placing the Fourth Amendment in the Constitution. In Britain, the Crown employed general warrants to go after political enemies, leading to the famous decisions in Wilkes v. Wood, 1763, and Entick v. Carrington, 1765. General warrants allowed the Crown's messengers to search without any cause to believe someone had committed an offense. In those cases, the judges decided that such warrants violated our common law. In the colonies, the Crown used the writs of assistance, like general warrants, but often unbounded by time restraints, to search for goods on which taxes had not been paid. James Otis challenged the writs in a Boston court, though he lost. Some men, such as John Adams, attributed this legal battle as the spark that led to the Revolution. Both controversies led to the cry that a man's home is his castle, where government can go only according to the course of our common law. King and Parliament, conspiring with East India Company beneficiaries and agents, were forever worming, as do bureaucrats and prosecutors today, to get around common law's due process requirements before searching and seizing things and people. The king's officers and clerks, using Admiralty law's writs of assistance, which the king's officers or even clerks were issuing in no more than hunch or hatred, broke into homes and warehouses at will without any warrant satisfying common law. James Otis' pamphlet denouncing the writs of assistance as contrary to freedom conceived the child called the United States, arguing the common law's sanctity of one's home and business. Otis's pamphlet, even more that Paine's common sense, birthed the child called America. In sum, British attempts to displace common law's freedom from unreasonable, unwarranted searches and seizures with Admiralty law's writs of assistance struck the spark that ignited American liberty. Our Declaration lists many of the ways King George and his cronies, seeking ease of administration for their tax-enforcing banking and trading monopolies, tried to force the devices of admiralty jurisdiction upon the colonist, such as juryless courts and warrantless searches. Nowadays, Amendment 4 is all but dead. Unless the jury enforces it, the police state's power to search and seize, steal, and arrest is limitless. Freedom is lost. The British followed Blackstone's error, insisting that the common law applies only on British soil. This, in Britain's American colonies, King and Parliament deemed common law rights no more than mere privileges, enjoyed only at Parliament's permission. Parliament's failure to recognize common law freedoms in the colonies meant three things. Slavery is allowed, the right to keep and bear arms is by Parliament's permission, and Parliament, at its whim, may rule its colonies using admiralty law, a form of Roman civil law, as are also martial law, canon law, and international law. Accordingly, Parliament banned independent juries and judges from enforcing one's rights against unreasonable searches and seizures. The text of Amendment 4 requires that all searches and seizures be reasonable. Hence, a proper written warrant is presumed reasonable. Thus, early on, courts found that searches and seizures of property and persons without a proper warrant issued from a neutral and detached magistrate, upon showing of probable cause that certain evidence of crime is at a described place, were presumed unreasonable. Nowadays, courts have forsaken this clear standard. Our freedom from unreasonable searches and seizures arise from the common law's castle doctrine. The American juror needs renew it. A man's house, said Justice Coke, is his castle. The poorest man may in his cottage bid defiance to all the forces of the crown. It may be frail, its roof may shake, the wind may blow through it, the storm may enter, the rain may enter, but the King of England may not enter. All his force dares not cross the threshold of the ruined tenement. Pitt speech before House of Commons, 6 March 1741. When an intruder enters one's home, the common law further protects the rights of defense of self and of others within. Moreover, Scripture justifies self-defense. The home defender who strikes and kills a thief caught breaking in at night is innocent. According to Exodus 22, says Matthew Henry, a man's house is his castle, and God's law as well as the common law sets a guard upon it. He that trespasses it does so at his peril. Both Amendment 4 and the American understanding of the castle doctrine are the English common law as it stood in 1776, which justified defense against criminal break-ins, says Blackstone, including a government agents breaking and entering without a good warrant. The law of England has so particular and tender a regard to the immunity of a man's house that it styles it his castle, and will never suffer it to be violated with immunity. No doors can be broken open to execute any civil process. A man may assemble people together lawfully to protect and defend his house. See example the 1795 case of Dan Winter's cottage during the battle at Diamond Crossroads, County Armagh, Ireland. The rise of the alphabet soup bureaucracies, police forces bespoke the end of the right against unreasonable searches and seizures. In fact, no significant court rulings on Amendment 4 occurred until after the late 1800s rise of federal bureaucracies. The income tax gave the federal police state its first real growth spurt of aggression. Following that came Prohibition, 1919 to 1933, between Amendments 18 and 21. Thereafter, FBI founding director J. Edgar Hoover, in league with Hollywood and comic book publishers, promoted the hero image of federal law enforcement agents, G-men. numbing Americans to renegade police tactics, taking them from deep distrust of federal police action to fawning acceptance of the police state's disrespect for Amendment 4. The federal courts acknowledging they have gutted the Fourth Amendment tells us to find remedy against government's abuses using civil rights actions. However, the only thing some federal courts dislike more than a civil rights action is a civil rights lawyer. We must therefore return to the simplicity of the Fourth Amendment's common law roots. If no written warrant meeting the elements of Amendment 4, then no entry, thus no search or seizure. Congress has grown the criminal law industry by feeding it from never-ending streams of crimes by legislation. Swarms of armed agents, score upon score of foreboding prisons and prisoners to crowd them. Americans nowadays even beg government agents to ignore Amendment 4 to catch petty pot smokers. In fact, a false rule now governs if government agents bust into your home without a warrant or other authority and find something the court wants to admit in evidence, it will uphold that lawless entry, search, and seizure. Thus, as a practical matter, the right against unreasonable searches and seizures is dead. Freedom's law, however, is forever alive, commanding that our courts protect our homes and us against lawless searches and seizures. Anyone, especially a government agent who kicks in your door, rifles through your belongings, and drags you or your things away without any warrant is a criminal. God help any thinking otherwise. See this handbook, U.S. Declaration of 76, sections 12 to 13, 28, and comments. Amendment 5. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. Comment. Amendment 5 distinguishes the common law tradition with its grand jury from the civil law tradition which has gone. Bottom line, no person can be tried for an infamous crime without a grand jury indictment, except when the defendant is on actual military duty in wartime, or during public danger tantamount to dangers of wartime. In cases of this exception, martial law, Uniform Code of Military Justice, applies. The phrase no person applies Amendment 5 to everyone, not Americans only. At common law, an infamous crime is a felony. The common law defines felony, however, not as nowadays according to possible jail time, but according to the dishonorable character of the offensive act. Thus, any crime punishable by death, example treason and murder, is infamous. In England and her American colonies, men were jailed not so often for punishment, but instead to hold them until their bail hearing, or, if the court denied bail, until trial. The Quakers' penitentiary, place of penance from which later grew the parasitic criminal law industry, never arose until decades later as a kind of Protestant purgatory, based on a false notion of mankind. See Brent Allen Winter's Excellence of the Common Law, Application 21. Americans nowadays allow government to abuse the grand jury, the common law shield against innuendo, deceit, and downright lies, with such silliness as to indict the peaceful, innocent, and productive for refusing to take part in the state's criminal law conspiracies to plunder the helpless. In addition, government, using legislation, regulations, and executive orders, falsely defines non-criminal acts as criminal and infamous, and then, using such unconstitutional definitions, obtains grand jury indictments. Never forget our Constitution empowers the general government to prosecute and punish only 4 kinds of crimes: treason, counterfeiting the securities and current coin of the United States, piracies and felonies committed on the high seas, and offenses against the law of nations. And of these four, it defines only treason. Criminal trials, says this Article 5, must be only on a presentment or indictment of a grand jury. Signifies two different ways to bring a person to criminal trial. One, the words on presentment mean that the grand jury investigates a matter on its own initiative, decides to indict, and demands that the U.S. attorney draw up an indictment for the grand jury foreman to sign as a true bill. 2. Indictment signifies the U.S. attorney's submission of a proposed indictment to the grand jury, requesting that the grand jury return it signed as a true bill. Grand jurors are too often fawning lackeys for prosecutors. As the Hyde Commission concluded, a prosecutor using a federal grand jury can indict a ham sandwich. Lacking understanding and confidence, grand jurors take the prosecutor's bit and trot harnessed together for him. Some grand juries have done their duty in taking control of an investigation, refusing to be the prosecutor's rubber stamp. Called a runaway grand jury as though it has run away from the prosecutor, as might a team of horses. Such a grand jury turns its powers of investigation upon runaway government hirelings, including the prosecutor. During the 19th century, many American grand juries, knowing their sworn duty, stayed independent and refused to replace their conscience with the prosecutor's will. During the 20th century, however, grand juries began fawning before prosecutors. In America's past, so-called runaway grand juries even barred prosecutors from entering the grand jury room. Nowadays, however, grand jurors have become lazy of their sworn duty to decide independent of any prosecutor's ambition, becoming the prosecutor's rubber stamp. "We trust you," said a federal grand juror to the prosecutor during proceedings against your commenter's client. "Just tell us what you want us to do." Our national motto, however, is not "in government hirelings we trust," but instead, "in God we trust." Amendment 5's exception clause, except in cases arising in, etc., excludes those under martial law jurisdiction from the common law's right to a grand jury indictment. Our Constitution here recognizes two categories of the armed forces: the regulars and the non-regulars. The regulars are the standing army and navy on active duty, whether in peace or war, and the militia when in actual service during war or public danger. Our Constitution keeps militia members under the common law's protection of grand jury indictment until the member has answered Congress's call under the Militia Act. The militia, i.e., the well-regulated militia of Amendment 2, martial law, a form of civil law, does not apply to the militant militiamen having yet to answer any call to muster. Thus, grand jury indictment is his right. Continuing with Amendment 5, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. Comment. This double jeopardy clause enforces one's right to never stand trial twice for the same alleged criminal act, a right secured, says Justice Story, by the common law. The right to be free from multiple prosecutions for the same offense, adds Justin Curtis, has been a feature of common law for almost 800 years. The right against double jeopardy more likely goes back more than 1,500 years, well before King Alfred the Great. The clause means that acquittal of a crime is final. To be twice put in jeopardy of life or limb means that no person is to stand trial twice for the same alleged felony. Whether the jury acquitted or convicted the defendant, this clause bars a second trial. Jeopardy means danger or peril, i.e., to be thrown in harm's way. In short, this clause limits the prosecutor to one go at trial of the accused, even where the mistrial is due to his error. The right against double jeopardy attaches to the defendant as soon as the jury is impaneled. For example, if the prosecutor drops the case just before all jurors are seated, the government may later try the same man on the same charges. If, on the other hand, the prosecutor drops the case just after the court has drawn and seated and paneled 12 men faithful and true, the right against double jeopardy keeps the government from ever trying again the same man for the same alleged act. Continuing on with Amendment 5. Nor shall be compelled in any criminal case to be a witness against himself. Comment. Indictment of the innocent for crimes, courts have said, is an unfortunate burden of being an American. Accordingly, our courts hold that the right to remain silent is for the benefit of the innocent as well as the guilty. Common law, said English lawyers, never requires any man to slit his own throat with his own tongue. American lawyers later put it that the law never requires any man to furnish the rope for his own hanging. Following Scripture's requirement of at least 2 witnesses to support each material fact of each accusation against a defendant lessens the government's tendency to violate a suspect's right to remain silent. Confession alone is never enough to convict. Simply put, if the state's only witness is the accused himself, another witness is still required to prove any material matter. If, on the other hand, all that is required for the conviction is the accused person's single confession, government is tempted to violate the dignity of the accused and therefore God's dignity, because God has made every person in his image by forcing him to speak against his will in order to get that confession. Moreover, the common law has always said confession is the weakest kind of evidence, and for good reason. Being accused befuddles the mind and befogs the facts, making one fear and doubt one's own innocence. In short, confession often comes out of a fearful desire to please or pacify the powerful. See Brent Allen Winter's Don't Talk to the Police for fuller discussion of the reasons behind our Fifth Amendment right to keep silent. Wisdom of the right to keep silent. The right to remain silent, says the Supreme Court, is for all and especially the innocent. One of the Fifth Amendment's basic functions is to protect innocent men who otherwise might be ensnared. Truthful responses of an innocent witness, as well as those of a wrongdoer, may provide the government with incriminating evidence. Ohio v. Reiner, 530 U.S. 1720, 2001. The following comment arises from convictions limbered in the forge of conflict, shaped on the anvil of trial, tempered by the teacher called time, and sharpened on the wheelstone of rumination, from having been interrogated and advising clients facing interrogation. Comment. When questioned, should you talk to the police? Experience says no. If you're married to a police officer, maybe, but be wary. To be sure, no is the right answer, but in America it helps to say no in constitutional terms and respond to each question asked with 2 words: objection, fifth. These words and no other, these and no more. Your commenter has further instructed clients to write these very words along with my telephone number on a piece of paper and to hand it to the questioning government employee. I have yet to find an exception to the simple rule: do not talk. The trite refrain, if you have nothing to hide, you will never be afraid to speak, is bad advice for 2 reasons. First, sometimes God desires silence nonetheless. See Brent Allen Winter's Excellence of the Common Law, subsection 4.8.2, discussing quickness to hear and slowness to speak. Second, government prosecutors are adept at twisting innocent and even exonerating words against the one having spoken them. Regardless of the innocent content of one's speech, the speaker must expect that the government will twist all that he says against him. Indeed, if given the chance, it will do so against the innocent as often as the guilty. Time has not shown that protection from the evils against which this safeguard was directed is needless or unwarranted. This constitutional protection must not be interpreted in a hostile or niggardly spirit. Too many view this privilege as a shelter for wrongdoers. They too readily assume that those who invoke it are guilty of a crime. Such a view does scant honor to the patriots who sponsored the Bill of Rights as a condition to acceptance of the Constitution. The founders of the nation were not naive. Ullman v. U.S. 350 U.S. 422 426, 1956. Though having otherwise spoken well here, the court errs. Amendment 5 enforces no mere privilege, but the right against self-incrimination. Whether innocent or guilty, the accused is often anxious to clear himself. As the early common lawyers used to say, once a man is accused, his conscience is on the rack, i.e., the mere accusation and fear of government power torments his mind. The desire to clear himself wells up and crowds his mouth with words. Amendment 5 confirms the American conviction that speaking truth draws ire from the powers that be just as often as speaking a lie, especially if the truth challenges government employees' lies. To be sure, all are duty bound to testify in court when called upon to do so by lawful process. Further, to be witness to facts favoring the falsely accused, but never come forward to testify, is despicable. See Leviticus 5:1 and following Proverbs 24:11. Nevertheless, the duty to testify under oath, like talking to the police, is dangersome. Accusations of lying are always possible. Thus, when in doubt, err on the side of silence. Say nothing. And remember, silence, like a wall of defense, does its best work when complete. In fact, silence broken is no longer silence, but a breach of your otherwise unconquerable wall. Therefore, never even explain your silence or your right to it. Just keep it. Silence, says Billings, is the toughest argument to beat. Supreme Court Justice Jackson put it clear. Any lawyer worth his salt will tell the suspect in no uncertain terms to make no statement to the police under any circumstances. Watts v. Indiana, 338 U.S. 4959, 1949. Justice Jackson follows the wisdom of the common law behind the Fifth Amendment, drafted out of deep convictions learnt in the crucible of hard lessons. Some advise to never talk to the police without immunity. But even that is dangerous because immunity requires trusting many unknown government hirelings to keep an earlier hireling's promise. To trust one man is risky. 2 is never advisable. 3 is reckless. God alone is trustworthy. When in doubt, do not talk to a law enforcement agent or other government hireling about any criminal matter, because at the whim of a prosecutor or his discovery of an obscure part of legislation, he will use your innocent words to mutate a non-criminal matter into a criminal case. Policemen and prosecutors are professional accusers, looking only for the bad, never the good. Bottom line, when we're wavering between silence and speaking, one ought to button one's lip, and more so when in real accusatory danger. Remember, government hirelings without fear of consequence will lie to you with impunity and make an art of doing so. promises of safety and assurances that you are no target of prosecution are meant only to weasel words out of you. And if you talk, prosecutors will twist your words against you or persuade the judge or jury that you have lied. But without your gift of words, prosecutors will likely have no case against you, or only a weak one. In fact, most convictions are self-inflicted, even though many prosecutors are poor trial lawyers. Being kept men living in the security of the taxpayers' support, they need only rely on the power and prestige of their position to incite fear and to draw fawning words from the defendant to use against him, and thus are less forced to beat the odds in trial, as is the defense lawyer. In short, the accused by his own words often convicts himself, because corporations are state-created fake persons said able to hold title to own property and afforded more privileges than even a real person can enjoy, e.g., power entice investors with the carrot of limited liability. Corporations have no right to remain silent. In short, corporate affairs are government businesses. For instance, all information you give a bank is open to the state and federal governments. U.S. v. Miller, 1974. Bottom line, upon government demand or court subpoena, corporations disgorge information. To sum up, Amendment 5 is meant to secure to you the Creator's gift of the right to keep silent, i.e., to conceal knowledge. See Proverbs 12:23. Keeping silent, however, is easier said than done. Few muster the pluck to resist the temptation to talk. But remember, says the sailor when in deep water, keep your mouth shut lest you drown. By baiting you to answer a few innocent questions, law enforcement will lure you into deeper water. Once there, your words are fatal. Never think otherwise. Your commenter has watched wily raccoons try to drown dogs by such a method. Once the hound is on the coon's track, he makes for the river where he treads water until the dog follows him into it. Then the coon, a stronger swimmer, climbs on the hound's head, grabs its scalp with his small claws, and holds him under until he drowns. Never follow a government agent or officer into the water. Bridle your tongue, button your lip. See further Brent Allen Winters, Shh, Don't Talk to the Police for fuller discussion of the reasons behind our Fifth Amendment right to keep silent. Further, and continuing on with Amendment 5, nor be deprived of life, liberty, or property without due process of law. Comment. This is the well-known due process clause. Its reference to taking of life acknowledges that the death penalty is not cruel and unusual under Amendment 8, as long as it results from having followed due process. Liberty is unhampered enjoyment of life and property. The phrase due process of law is shorthand for due process according to the course of the common law. Even if government has power to take all that you hold in this life, liberty, and property, it has no right to do so unless it has followed common law due process. At bottom, notice to you of its claim and a genuine opportunity to be heard. Define further, definition fitting due process best becomes known as needs arise. No pancake is so thin that it does not have two sides. Due process requires that both sides of a disagreement have an opportunity to tell the other side. Of note, common law's due process, Magna Carta's law of the land, barred government or any other power from taking a man's wainage, plow, tackle, and ox team. Common law bars government from robbing any man of his natural right to make a living, even though deemed guilty of a high crime. Nowadays, however, in derogation of common law rights, federal prosecutors use devices and schemes prior to trial and conviction to keep the accused from making his living so that his family can eat and have shelter, while at the same time retain good legal counsel for his defense, also a fundamental right. See this handbook, U.S. Declaration of 76, sections 26 to 27, and comments. Again, with Amendment 5, nor shall private property be taken for public use without just compensation. Comment. This is the well-known takings clause. As a routine matter nowadays, government and courts force people to sell their property if a mall developer or sports team wants it, arguing that the framers intended the phrase public use to ensure the public's comfort while shopping and to satisfy the public's lust for the frivolity of games. The so-called war on drugs has further lifted inhibitions. Government will now take your car or pickup truck and all that in it is, including tools or other property, without paying any compensation if somebody else commits a drug offense in your vehicle, all in violation of this takings clause. By such taking of property called the instrumentality of a crime, without any compensation, governments follow an ancient pagan admiralty civil law practice that says mere objects are evil. At common law, however, only a person, never a mere thing, can be adjudged evil. And even then, only after the government overcomes the presumption of that person's innocence. Indeed, evil persons use tools to do evil, but a mere tool, having neither mind nor will nor duty, is ever evil. Thus, this clause allows government to take your property only for public use, in which case it must pay fair market value. See this handbook, U.S. Declaration of 76, section 16, and comment. All right, that is all for this week's reading, and I will see you on the next call. Peace and love.